Fantastic. Thank
Yes,
you,
sir.
and good afternoon, Chair Martin, esteemed members of the committee. My name is Vasu Abhiraman. I'm the Senior Policy Counsel at the ACLU of Georgia, also a graduate of multiple Georgia public colleges that will be covered by this bill. We have, of course, been tracking and testifying as a free speech organization on various versions of this legislation over the years, and we do recognize and appreciate that meaningful improvements have been made in this bill. We do remain concerned with various provisions within HB1 that could hinder First Amendment rights on campuses. Based on the current version, the committee substitute, I believe the lines we're most concerned about are 34 through 38, 40 through 42, and 156 through 157.
Let me ask you to slow down and repeat those lines for me again, if you would.
Sure. These would be lines 34 through 38, 40 through 42, and 156 through 157.
Thank you.
The first, I want to bring our attention to existing law, OCGA 20-3-48, which specifies goals of fostering the transmission and dissemination of knowledge by means of, among others, debate of different ideological positions, and also establishing that our institutions of higher learning do not exist to shield students from speech protected by the First Amendment. The sections of HB1 that we are concerned about may run counter to those stated objectives by chilling the rights of demonstrators and counter-demonstrators on campuses. For example, the bill makes a few attempts to describe what behavior is prohibited. In lines 40 through 41, an individual may not create loud or sustained noise or vocalization. And in lines 156 through 157, it excludes minor, brief, or fleeting nonviolent disruptions, those that are isolated or short in duration. Neither of these provisions truly creates meaningful guidelines that provides individuals with the ability to determine what conduct would be prohibited by this bill. The Supreme Court in the city of Chicago versus Morales held that a law can be vague because it does not give an individual notice of conduct that is prohibited, or because it allows for arbitrary and discriminatory enforcement. As previously mentioned, the provisions contained in HB1 that do not provide adequate notice of what conduct is prohibited due to the wide range of conduct falling between the aforementioned isolated and minor, and then the loud and sustained noise. The bill also introduces multiple elements of subjectivity, which lack the specificity required to merit an infringement on First Amendment rights. What one student may deem a minor disruption could be a major source of distress to a different student. This would allow the same conduct to be penalized differently based solely on the perception of the receiving audience, resulting in possible arbitrary enforcement. Now, attempts to define First Amendment rights frequently present such vagueness and chilling effect issues, and we do see some of those here. The ACLU of Georgia believes that this legislation is not truly necessary in its current form, and at the very least, this committee should take a closer look at those sections that may not provide adequate notice of what is allowed as expressive activity on campuses, and therefore may chill speech. Of course, the First Amendment not only protects the expression of an idea, but also the ability of those to confront ideas that they disagree with. Thank you. I yield for any questions.